Welcome back. We're all here together. So we're going to finish up mediation, and I told you that before we left. There was a case that I had at Postal Service. That was really an awesome case. They specifically asked me to come in and work with this group. It was a group, and the great thing that's with mediation is, you know how you can have when people go to court and they're litigating and they have civil suits and things of this nature. There's a large group of people that's involved, litigants and stuff. But anyway, this was really a really good one because it was like 10 individuals, all females. And so you had 5 that was American, and then 5 that was Caribbean. And so it was different disputes that they had with one another. And what the thing that was interesting with this one is that they all worked together, truly liked one another. But things happened and began to fall apart. And what's so really good about mediation is that you really do allow individuals to speak to one another once they begin to start. And that's why a mediator is so important, to be able to, you can ask questions, but again, you're not trying to put out a lot of stuff, but if someone says something, you can help people, especially when an apology comes. When someone apologizes and another person's yelling, you could freeze frame, say, did you hear what so-and-so said? They apologized.
Mm-hmm.
Do you mind doing that one more time? They're listening. They look at one another,
right,
and all the ice is broken. So with this situation, briefly, is it was a large room, and at a large facility, they gave us a big office. So was sitting all kinds of ways, this way, other sides over there looking like this,
mm-hmm,
sitting like this, we'll look at one another. So that was the agitation level.
mm-hmm.
But the thing about it that was really good is that we spent a lot of time, some hours at this. But in the end, after a little yelling, some words, tears, sorrow, I didn't know. I'm so sorry. I forgive you. We're good. That's briefly.
Good phrases.
2 hours. But the thing about it was beautiful. It was heartfelt. And it was so good to see these women come together and everyone hugging. I'm hugging. They're hugging. And walking out in a different place than when they came in.
Right.
And this is what happens. It can happen in a mediation. All of them do not go like this.
That's right.
They all don't go this way. And not all the time does someone reach across and shake the person's hand at the end. But that does happen. That does happen. People do look at it, and the opportunity to be involved in a mediation, even as the respondent or the charging party, is that, and especially as a mediator, to actually see the human dynamics,
right,
in play, the good, the bad, the not so fab, but then people to see it's on the table. Sometimes their heart is laid out there. Sometimes people want to step on it, stab it, and do a variety of things.
right,
But then some actually want to heal.
right.
And that's the whole thing about mediation. It gives you that opportunity, if that's the part you desire to take,
Right.
to heal from whatever transpired in your workplace or wherever. And that's why they have divorce mediations.
Mm-hmm.
They have siblings. They have for child custody. There's mediation for every type of situation,
Right.
here in our country and around the world.
Mm-hmm.
We engage in all these processes, and even though we facilitate, we mediate, we arbitrate, we do negotiation, we do all of this stuff. There's a place for each part that's on the spectrum.
That's right.
But I must say, speaking for Arthur as well as myself, we love mediation.
We do.
To see people come together, get their statements out there, get their stories out there, and to go on.
And the last thing I'll say before we move to arbitration, in any mediation process, the mediator provides a different voice,
Yes.
a different optics, a different lens. So a lot of times, because the anger is such palpable,
Yes.
the stakeholders are so entrenched and they're so positional, that mediator provides maybe a breath of fresh air
Yes.
and could help the parties at least coexist in the same space together.
And remember, because we mind those we train, because we're trainers for the mediation process, reminding individuals, those that are attorneys, When you walk into that room, that is not what you do. You're not an attorney. You're not a litigator. We do judges, train judges. You're not a judge. You're going to have to take off your cloak. You cannot be there with that. You're there to mediate. It's a different thing. Whoever you are, whatever your job, when you walk in there, you are a mediator. You're a neutral. You cannot forget that. You have to leave everything else outside and allow this process to unfold and the parties to speak. You're just there again, navigating. People have the opportunity. I don't want that path I'm taking. I'm not going left. I don't want to go right. Rerouting. And you just sit there and be like Susie, our GPS. Listen, rerouting. You want to go another route? Let's just reroute it. Let's just do a different thing. You need to have patience and a lot of other things too. So,
right.
Yeah. So we're going to move on to arbitration.
Arbitration. So let's talk about where arbitration really has changed the way we do business.
Yeah.
And we're going to give some examples and then talk about some of the ebb and flow of arbitration.
Yeah.
We mentioned it earlier. Arbitration clauses are a big part of business-to-business transactions.
Yes.
Arbitration clauses are big in the entertainment industry, relationship between unions and management, on Wall Street. We can go on and on. The main difference between arbitration and mediation, and again, folks, not giving any legal advice here, just guidance. You may want to consult with an attorney if there's an arbitration clause that is part of a contract you have, whether it's with your lease, your mortgage, your 401k, or any of these contractual documents. Look at the fine print. If it says arbitration, you still have that third party, Sakia.
Yes.
The main distinction is that an arbitrator is going to listen to evidence and make a final binding decision.
Yes.
If that is the parameters for that particular arbitration. It's a final binding decision. And so the arbitrator listens to evidence. Now, let's try to talk a little bit about the types of evidence that are part of an arbitration process. Now, the best way to think about arbitration is think about any shows you may have watched growing up, or shows you still watch on television, such as Boston Legal. You have NCIS, you have Criminal Minds, you have My Cousin Vinny. We can give you all these different examples of shows that have courtroom scenes. The main difference is that an arbitration proceeding is not criminal, it's a civil proceeding. Arbitrations take place in conference rooms.
Yes.
Arbitrations take place at libraries. Arbitrations take place at lawyers' offices. They take place in neutral sites where the parties come, they present their evidence, and the arbitrator usually has a certain amount of time to render a decision. I'm going to talk a little bit about the 5 different primary types of evidence, and then Evelyn's going to talk about a couple of cases that she arbitrated. Now, here's the thing. I would say from a formalized process, arbitration has been around as a formal process many, many years. If you look at the American Arbitration Association, which we have a relationship with, they were founded in 1926. The Federal Mediation and Conciliation Service was founded in 1947. They have a roster of arbitrators. You have Judicial Arbitration and Mediation Services, where our colleague Chris Clark works. They have a huge portfolio on arbitration cases. Arbitration has been around. It's part of contracts, as we mentioned. 5 different types of evidence in an arbitration that are important. Number 1, testimonial evidence. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Number 2, demonstrative evidence. That could be a PowerPoint, presentation. Number 3, physical evidence. It could be a time clock or a tool. Then you have documentary evidence, which is memos. Could be a commendation. And then you have hearsay evidence, which, as many of you know, in a criminal proceeding is not admissible. Hearsay evidence may have some probative value in an arbitration process. So Evelyn, if you could just talk a little bit about, you've had a chance to arbitrate on Wall Street. You've also had a chance to arbitrate through the New York State courts, as well as other tribunals. You want to give us a sense of the arbitration case that you had, where you were one of 3 arbitrators in the case involving the New York Stock Exchange, without obviously revealing the facts, but just kind of talk about how the arbitration was structured and how in that particular instance you were not the sole arbitrator.
No. So you have, I'm just, you know what? Before we go there, we're going to take a break. And we're going to come back and allow you, again, sustenance, whatever that means for you. Go ahead and do it. Get your vitamins and get a little quick workout. You come on back, and we'll talk about the case. 98.7 KDIV, Transformational, Thursdays, here one, Elevated Dialogue. Okay, we are back, everyone. And I told you and promised that we were going to talk about this particular case. And you know what it is? It's not a particular case, but just to let you understand what these cases were about. And so this is with 3 arbitrators, and I represented the public. And the other 2 arbitrators were very familiar with the financial world and things of that nature, so they were involved with that. So they needed someone from the public, and that's my chair. So it was interesting because essentially what this was all about for the New York Stock Exchange was an individual who felt that their stockbroker did not treat them fairly or engage in transparency with stock in terms of how they sold them the stock, why they sold them the stock, or they did not sell it when they wanted to get out, things of that nature. And so it's really, it's interesting. Remember you talked about with many of these you need to have legal representation. But many times the individual that's the charging one or the one that's I have a violation that I think took place against my person, people come to mediation as well as to arbitration without representation. They come with a friend, if they come with anyone. They come with a family member, their son, their daughter, their wife, whatever. They don't come with legal representation. So the point is, that's not held against you. You need to know that. That's not held against you. Because that's what the arbitrator is there to do, to make sure whatever is being presented is correct information, is correct. Ask questions. Now see here, the arbitrator asks those questions. They're going to ask, they want to see some documents. They're going to pass those things out for you to see how you're defending yourself or what are you saying happened. So when it came to this, what was really great is that, again, you didn't have representation. Many times people came with just themselves. Some people were well organized with paperwork.
Right.
How many of us are that way?
That's true.
Okay.
So let me just say this, and then I'm going to let you talk a little bit about that case. We want to kind of structure for you what a typical arbitration looks like.
Yes.
You have opening statements.
Opening statements.
Now you may have some document exchange. Remember, arbitration is a little more formal than mediation, but less formal than litigation.
Yes.
Okay, so you have opening statements, you have direct and cross-examination.
Yes.
You have introduction of documents, which you're going to talk about.
Yes.
And then you have closing arguments.
Yes.
So that's kind of the
expeditious
framework for arbitration, and understanding that certain parties, depending on the circumstances, have the burden of proof.
True.
Okay.
So as we're gonna delete arbitrator, we'll give direction of how the.
So you were a tripartite. You were part of a 3 arbitration.
Yes.
Process. Okay.
And you did have a lead arbitrator, and then you had others. But the decision process of how this decision was going to be made was joint. Actually sitting there, going over everything, and everyone had an opportunity the same to discuss how they felt about particular aspects of information that was given, or whatever was presented, going through it and saying why.
So at the conclusion of the arbitration, the 3 of you deliberated.
Yes, very much so.
And the reason why it was an uneven number is in case there was a tie.
A tie.
That's right.
So someone had to break that one. So it was like that. So so the lead person would explain everything. And when you talk about documents being presented, oh boy, normally, again, some individuals would come with a binder, their information laid out, and you have to have copies for the 3 arbitrators as well as for the other side.
Right.
So they would come with everything, organized. Others were not so. They try their best. And how many of us, if someone asked you, listen, I need that document from a year ago, really going to be able to pull out that document? So people are that way. They come with the best that they come. They come with scribble paper. They come with a variety of stuff, but that's still going to be presented. that is still evidence
Right.
that is going to be looked at.
Mhm.
But what's also important, as you stated, they get to speak.
Right.
They get to have a voice. They get to say what happened.
Right.
They get to tell you about a phone call. They get to tell you, I did call on this day that said sell. Told me not to. Told me he was coming back. I said, but they sold me something that I didn't need. So these things, go ahead.
Well, and what you're saying, though, those kind of questions are a little different in mediation and arbitration,
Yes.
where that individual is actually being presented with questions
Yes.
on direct examination, but they're also being subjected to questions from the other side
Yes.
on course examination.
They can. Yes.
And the arbitration process, although not as formalized, most arbitration processes require you to tell and take an oath or affirmation.
And not everything is allowed either, just like court. It's like, no, we're going to disregard that. And you got to make the evidence has to be correct in terms of what you want to say, the hearsay, what you were just stating. All of that is looked at. Mm-hmm. So, and just because an individual might not be organized in their formal material,
right,
their memory also counts. I spoke to, boom, bop, and all of that. And then some people do have some things that can stack it up. So just a reason I'm stressing that is because a decision is just not made solely on who has the best presentation in terms of material. Because the other side, which would be the firm, will be coming in 8 to 10 to 12 individuals deep with what you call the thing you put the boxes on, the carrier, the cart. And in those carts, on the cart will have like 6, 8 boxes, bins of folders. Everything's inside.
That was in this particular case you had. Yeah. Not in case that voluminous.
When you were dealing with the stock exchange, a lot of them had. They came with a lot of information.
That's right.
Because we're talking about people with some serious money.
Right.
Lots of money. We're talking millions. They had a lot of money, and things were going down. So they came with a lot of information, and they're going to come. Remember, with all of that, passing it all out to everyone. So each of us had the material to go through, to look at the documentation, to ask questions, and things of that nature.
Well, here's the other thing we want to talk about, and we had the chance to be involved with this, is that you remember the time I spent almost 2 weeks in Bermuda.
Oh, yeah.
I was part of a tripartite as well. There were 3 of us that were arbitrators, and we had voluminous documents as well. So all the different types of evidence that Evelyn and I have articulated were part of that case as well.
Yes.
Okay.
And that's important.
It is, because you have to review the evidence, and it's a credibility determination.
Oh, that's so important.
Which is important to assess who do we think is most believable.
Yes.
Who do we think is being honest and forthright, and who do we think is testifying in good faith?
Yes.
And you have to weigh all the evidence, all the facts, listen to all the testimony, review all the documents, look at all the evidence, and be able to make that determination as an arbitrator.
And it's really good when you're on the panel to listen to those that are attorneys, that they can sincerely, especially with the one for the divorce attorneys and the client, to actually listen to the attorneys in private, to be able to weigh and say, oh, that wasn't fair, that was incorrect, they charged for this, they did this, that was not right. To know that they're in that business and still able to say, no, I'm going to strike that. They don't owe this because this is about them paying. The client didn't want to pay for various reasons, and them being honest and say, I don't do, no, that's incorrect. You don't charge for that.
Well, let's give the listeners a little construct of what you're talking about.
Okay, yes.
That was the arbitration you did where there was a fee dispute.
Fee dispute.
So now we
moved on from the stock exchange.
That's right. So we're away from Wall Street now. We're talking about, in many jurisdictions, there's arbitration where you have an arbitrator that will determine whether the fees that were charged to a client were reasonable and fair.
Yes.
And so those disputes actually go to the arbitration process. And the arbitrator decides, based again on evidence. That doesn't change anything.
No.
You got to weigh the evidence that's being presented and the credibility determination of the witnesses.
And again, what's great about that too, you have a party that's not the attorney, not an attorney, but you have 2 that are, and you have one that represents the public.
I realize now that you were on 2 panels where you were in a tripartite model.
Yes, and it's really wonderful because I think I've been blessed to have my partners in this, the other arbitrators,
Right.
that were fair,
Mm-hmm.
they were correct,
Right.
and they actually valued the transparency
Mhm.
and the truthfulness of the process,
Exactly.
and not to take sides with their fellow comrade
Right.
that's in the business or the field.
Sure.
That's what they do. They all attorneys. Let me just side, because sometimes people feel
Right.
that because you're in the same industry, you're going to automatically side with that other individual.
Absolutely.
They did not do that. They actually looked at it correctly and said, that wasn't right, those fees.
Sure.
You shouldn't do that.
Right.
And everything at the end, whichever one you're on panel, there is a decision that is made.
Mm-hmm.
It is fully laid out why that decision was handed down.
Right. And as we move towards a break, just wanted to let you folks know that although we presented a number of examples of three-party arbitrations where there were three arbitrators, there's plenty of cases, which I will talk about one or two when we come back from the break, of a solo arbitrator
Yes.
that does the same thing that the three arbitrators do. And essentially, and there are some that are recorded, where there's a court stenographer, and there are some arbitrations where the arbitrator is taking copious notes. So we'll talk about that after the break. 98.7 KDIV, Transformational Thursdays. Evelyn Sakia, Arthur Theotis, we're Elevated Dialogue. Okay, before we went to break, Evelyn Sakia and I were talking about the arbitration process. And I've been in a number of situations where I've been a solo arbitrator multiple times over the last 20 years, 25 years. And the most important thing is being civil and respectful to the parties. As an arbitrator, we have a good friend we want to say hello to, Jacqueline Drucker, who's one of the best arbitrators we know in the entire world and the country. She's in New York, and she travels all over the country doing what she does. She's also a part of the National Academy of Arbitrators, where she has received countless awards for her contribution.
Who we do training for.
We do. That's right, absolutely. So part of this sole arbitration model that we're talking about that Jacqueline Drucker does, we don't do as often as we used to. We really love the mediation process. But when I was a sole arbitrator, it was important to walk into the room. And here's the thing, and Jacqueline and I and Evelyn and John, her husband, have had a lot of conversations about this. The role of an arbitrator can be very lonely because you are that neutral third party, and a lot of times you can't get on the same elevator that you think the parties will be on because the appearance of a conflict of interest. You have to find out where the restrooms are at different floors. Those are the kind of things you have to be really mindful of. And also as an arbitrator, where I've arbitrated cases in the utility industry, in transportation, etc. You walk into the room, one side is already there, and I'm always getting there 30 minutes early, but if they're there already, I would not sit in that room. I would go into a neutral room and wait for the other side to come. And when both parties are there, I will enter the room again. Never want to give the appearance of impropriety or that there was a conflict of interest. So a typical arbitration would start with, ladies and gentlemen, thank you for being part of the arbitration process.
Just before you begin with all of that,
Sure.
all that he just stated is the same for a mediator. The mediator does the same thing.
Oh yeah, in terms of
just
conflict
let
of
you understand
interest.
that a conflict of interest,
That's right.
You don't want to engage with them by yourself, not in a room with one party and over the other. So everything you stated,
That's right.
just wanted them to know
Right.
that works the same for mediation,
It
because
does.
you always want to make sure that people don't think that, oh, you're more friends with one side than the other.
That's
Same
right.
thing,
So neutrality, no, that's really important.
Neutral, yeah. Go ahead.
So I would say to the parties at the very beginning, once they're all assembled, ladies and gentlemen, are there any pre-arbitration matters we need to discuss? Some arbitrators will say to the parties one last time, did you, ladies and gentlemen, have a chance to have any discussions today about a possible settlement? Because here's a distinction between mediation and arbitration, which is profound. Once the arbitrator opens the record, for the most part, with very few exceptions, now that case is now fully being presented, and that arbitrator under AAA rules, the American Arbitration Association, for example, will have 30 days to render a decision once he or she had reviewed the evidence and made a determination about the case. So a lot of times, as you know, Evelyn, you and I would talk about this, when they walk into the room and they see me as the arbitrator, the parties realize this is their last bite at the apple. So they'll actually say, Mr. Arbitrator, can you give us a few minutes? And I'll actually go into the hallway, engage in some settlement discussions, and actually come to a decision. Because the realization when they see me is that, or see you, is that now the record's about to be open, and there's going to be a determination being made. This might be my last opportunity to talk to the other side.
So the decision is taken out from their hands and is given to the arbitrator to make the decision, like when you go to court. The judge and jury.
That's right.
So that's just why mediation is important, because when we make a resolution there,
right,
that's between the parties making a resolution.
That's right.
And that's why each of these areas on the spectrum that we've been discussing is so important for you to understand your place in all of that.
That's right. So I think with the arbitration process, a lot of parties, quite frankly, in the experience that we've had, they want to arbitrate this decision. They want to be able to say, we have a decision that's binding. And there are some environments, and they know who they are, and it's fine. They actually will post the arbitration decision on the bulletin board, because again, with arbitration, it's usually a winner and a loser. Okay, in mediation, there could be a win-win if you're facilitating a compromise or collaboration between the parties. But in arbitration, for the most part, somebody won and somebody lost.
Right.
Because it's very much, if you will, like a criminal proceeding or a courtroom proceeding, where there's usually a winner and a loser. Okay? So is there anything else, Evelyn, Sakia, you want to talk about with arbitration before we kind of move into another area and then introduce our listeners to our next concept, which we will finish in a couple of weeks, which is the form of discrimination that is near and dear to us, sexual harassment awareness.
Just understand, just play this again, folks. Understand what you're doing. What's the undertaking of all the processes? Which one best works for you? But again, understand this. Many times, once you sign on that dotted line or check that box on the computer, on your tablet, on your phone, the decision is made for you which process you're going to be involved in if there's a disagreement or a dispute.
Right.
Understand what you're reading. Stop being so quick to check the box,
right,
so you can get onto your app and continue your process. So at least you understand, even if you don't do it, at least you're going to now understand a bit more about when they say, okay, you have an issue, you're going to have to go to arbitration, so you can understand what this is all about, understand your rights a little bit more,
right,
as well as mediation. But again, you need to pay more attention to the things that you're doing in your life. Everything is going to lead you to one of these processes. If it doesn't lead you to court for litigation,
right,
you're going to have these other alternatives, okay? So please pay attention to that. And we enjoy doing them all, as we told you.
Sure.
But we really enjoy informing you and for you to understand what your rights are in this world that we're living in now.
And here's the thing, folks, just as a reminder, I believe we mentioned this in a prior show, that 97% of all cases, all conflicts that come up, particularly here in the United States, 97% of them are resolved either through facilitation, negotiation, mediation, arbitration, or some form of alternative dispute resolution.
Yeah.
All right, so there's only a small percentage of cases that make it to trial and go through that lengthy process called litigation, where you have discovery, interrogatories, dispositions, or depositions. So it's a good thing when you're involved with the process, but you have to be informed.
You do.
You know, and a lot of times you don't have a choice, quite frankly, on which process. If you sign that contract and you didn't really read it properly, then, you know, if it says it's an ADR clause and they use mediation, well, guess what? That's the process you're going to have to use, and you need to know what it is. Okay? All right. So let's move to sexual harassment awareness.
Yes.
Now let's just start with some parameters. First of all, huge issue in the workplace, one that is disturbingly increasing by leaps and bounds, regardless of industry. Evelyn,
Yes.
Sakia. Corporations,
I don't think anything is.
non-for-profits, NGOs, labor unions, municipal, state, local governments. It's been trending quite a bit in the news. And we just want to say this, and again, this is not legal advice. We want to be clear, consult with an attorney. However, sexual harassment is a form of discrimination. Sexual harassment is a form of discrimination. Sexual harassment is a form of discrimination. We'll start with the federal protections under the EEOC, which is an agency we've talked about quite a bit in a few of our shows. EEOC is the Equal Employment Opportunity Commission. They were founded in 1964 as part of the Civil Rights Act of '64. They began operating in 1965, and they continue to operate every day across the country. They have regional and district offices. The EEOC through the work of these federal sector employees, concerned about all aspects of discrimination, and one that has been trending upward is sexual harassment.
Yes.
Okay, so what we want you to do is think about this in the context of being in the workplace and understanding that sometimes your organization, and Evelyn's going to kind of share some keywords about policies and procedures that might be at your organization that address the issue of sexual harassment, because it's such a big issue in the workplace.
Mm-hmm.
So Evelyn, you have a definition here that you wanted to kind of talk about a little bit in terms of what it looks like and what it says.
Again, the definition, though, what we want you to do too is when we finish this today, understand something, just again, to reaffirm here, is that we're talking about federally, that Title VII. So we want you really, it's long. When you have a moment,
Right.
look it up.
Mm-hmm.
Look it up and read it and see what this is all about.
Right.
Not that you're going to understand everything, but we're going to try to give you a little bit of clarity about it. But again, when we're discussing today, we're pretty much talking federally.
Right.
We're going to talk about, we're going to just give you some things that some organizations do.
Right.
Not every organization. Then we'll talk about the distinction between what some organizations do and then what the federal government maybe does not have included.
Right.
So let's just discuss, like, some organizations, and we've worked with everyone in a variety of arenas.
Mm-hmm.
We cannot open up a newspaper or listen on television, and this is going on even in churches or religious places, schools. Okay, no matter how it's there. So sometimes organizations have something like this. I just want to read what many organizations have. Okay, yours might not have that. And if you work at an organization, maybe you want to look and see what they have and
Right.
read it, because many times you get your employee handbook. How many of you read that? That's again something that you have signed,
Right.
and who reads that?
Right.
You just sign it. So want you to get this, read this to you, and we're going to come right back at you. The organization will not tolerate sexual harassment and any other discriminatory harassment on the basis of race, color, sex, religion, pregnancy conditions, national origin, age, sexual orientation, gender identity, and/or expression, veteran status, marital status, qualified disability, genetic information, which includes family medical history,
Mm-hmm.
or any other characteristics protected by the law. Again, this is not Title VII. This is what many organizations
Right.
include for their people. And the thing about this, the federal government, we'll talk more about that when we come back on a break. We'll talk about the differences
Right.
between what organizations provide. But again, we want you to read Title VII for United States,
Right.
what that covers. We'll talk more about that when we come back from a break.
And let me just say this,
Yes.
some of what Evelyn just read is part of Title VII.
Yes.
The language that we're talking
Yes.
about here. So that's important.
We'll
for us
make
to
the
understand.
distinction of maybe what we might be.
And last thing we want to say before we take our break, for those of you that are working gainfully employed, look for the EEOC poster.
Yes.
It's on your bulletin board, it's in your break room, it's in the cafeteria, it's near the elevator.
That's the Equal Employment Opportunity Commission.
Right.
Sometimes it just says the EEOC. It says Equal Employment Opportunity Commission. That's the EEOC.
Right.
It should be in every place that has employees.
At least 15 employees,
Here you go.
with some exception.
With some exceptions, you should have that there.
Right.
Find it. It might be under someone's desk behind the door someplace, but it should be in that cafeteria, any place where you converge. We'll be back. We see you, KDIV 98.7 on Transformational Thursdays. Elevated Dialogue.
Okay, so when we left you, and welcome back, this is KDIV 98.7 Elevated Dialogue, Transformational Thursdays. Evelyn Zakia, Arthur Theotis, talking about the issue of sexual harassment. Evelyn gave you an example of some language that you might see in your company policy. All company policies are not the same. Let's be very clear about that. All laws are not the same. What we will tell you is that we know quite a bit more about the EEOC because they've been a client of ours and we've had a relationship with them for over 20 years. As you travel north, south, east, and west, the state laws, county laws, municipal laws, city laws could vary on the issue of sexual harassment. So what Evelyn Zakia and I strongly urge you to do is to consult with an attorney. If you feel that you're a victim of sexual harassment, that you would retain an attorney to find out what your rights are in the jurisdiction that you're talking about. For example, New York State has 62 counties. They have a lot of protections. Federal level, of course, State Commission of Human Rights, New York City Commission of Human Rights. Here in Arkansas, there are 75 counties. In Oklahoma, there are 77 counties. There are certain municipalities that may have protections, but again, make sure that you do your due diligence. Make sure you talk to an attorney and find out exactly what your local municipality, your county, or state has in terms of possible protections. And for employers, you want to do the right thing, okay? And we know you want to be proactive about this, so there's a lot of municipalities across the country and a lot of states that have mandatorily required sexual harassment awareness training for their managers and their supervisors. That's really important. Folks, there's one issue that's trending at the highest level in our workplaces that causes more liability than any other issue, and that issue is sexual harassment. Okay, Evelyn, is there anything else you want to add?
So your homework, as Arthur already stated, is a few things. We want you to read the Equal Employment Opportunity Commission Title VII.
Specifically around sexual
harassment. Read that. Then you're going to look in your town that you're living, or your city, or your state, and find out what they have when it comes to that. Okay? And importantly too, your organization, see what they have. Go to your employee handbook, go to HR, go to whatever you have, and see what they have on that.
Right.
That is your homework. So when we come back together, you're going to have that. And we're going to continue this discussion because it's a very important discussion. But until then, we want you to be well, to be safe, and there's nothing wrong with just being civil. It's a good thing. Being correct with another human being. Being mindful of the words that come out of your mouth, and be mindful of what you're looking at and how you're looking. We won't get more into that when we come back together. We're going to really give you the lowdown on the do's and the don'ts, just proper behavior, and how we just need to make sure where we look and where we don't, in a variety of other things. And we're going to bring up some other companies, for various fields, so that you can really see it's everywhere. No one's exempt. You got to be careful. And this is going to also help you. You got teenagers that's going for their jobs. Their first job, 14, 15, 16, 17, 18. And even those you that's already been in the job for a while. So you can know what to look for, what to do, how to handle this.
Exactly. And here's the other thing as we kind of finish up this segment. In the sexual harassment space, you have a perpetuator and you have a victim. And it's important, sometimes the victim feels overwhelmed by someone in a position of power. And sometimes, folks, we see this sexually harassing behavior taking place, but it's not directed at us. It's happening to a coworker or a colleague.
Yes.
We have to learn how to be allies. And in our next show, we'll also talk about third-party harassment.
Yes.
And that sexual harassment is not just about touching. Evelyn will walk us through kind of the nonverbals that can constitute sexual harassment. And the other thing you want to be mindful of is understanding that in most instances, when we have this kind of behavior that's circulating, it's never a good outcome. But sometimes those cases, believe it or not, can be properly mediated. And the victim really simply, and Evelyn said this earlier when she was talking about what everyone really wants when they're conflicted, in most instances, in 85, thereabout percent of the cases, the victim of sexual harassment are women. We have about 16 or 17% of the men, so about 80 to 82% are women. They're still the victims at an overwhelming level. But we can also, we're going to talk about this same-sex harassment, which now has started to trend as well.
So we got a lot to cover. We have quite a bit to do. We want you on focus, on page with us, so that we can put an end to this, as well as more civility and respect, with more understanding of other human beings that look like us, that don't look like us. Go where we go, don't go where we go. Big, small, short, tall, it doesn't matter. We want to be able to be in this world and have the freedoms to be who we need to be, but also respecting all the other folks that's around. So this subject matter is not just for adults. We need you to have your teenagers listening,
Right.
because we're going to talk about teenagers. We're going to talk about everybody, because sexual harassment affects all ages.
It does.
No one's exempt.
That's right.
No one.
And here's the last thing we want to say is this. For many of us, sexual harassment may not be as important enough issue because we haven't been victimized by it. And that's fine. And thankfully you haven't been, because it could be debilitating. It can affect your productivity. It could affect your ability to come to work.
Yes.
People have had to seek all kinds of support and help that have been victims. So this is the one thing that Evelyn is alluding to that I'm going to say just very clearly. Even if it doesn't resonate for you, think about your daughter, your son, your nieces, your nephews, your mother, your father, your grandmother, or your grandfather. The simple question is this: would you want any of the people you love to be a victim of sexual harassment? We're going to leave you with that and be able to talk to you the next time in more details about this very important issue. That is, quite frankly, it's one of the most serious issues in the workplace today. And we're going to talk more about that the next time we get together.
We want you to be careful, be peaceful, be mindful, show respect, and let's just be good to one another.
Sure.
Peace.
Okay.
KDIV 98.7, Elevated Dialogue, Transformational Thursdays. We'll see you again.